There we go. Thank you for your patience, everyone, as we get our technical issues set up here. So I'm going to call the meeting to order. Good morning, everyone. I am Kathy Lewis, the chair here, and this is the Board of Appeals, May 15th, 2026 meeting. It's being held both in person at the Hilo Council Chambers as well as virtually via the Zoom platform. So I'd like to just set some ground rules for those of you that are appearing by Zoom, please. You should, if you are participating, you should have your cameras on at all times. One person should speak at a time with no side conversations, as that interferes with our hearing what the main conversation is. You can mute your device when you're not speaking to improve the audio quality for everyone. And please raise your hand and wait for recognition by me if you wish to speak. Before speaking, that way we ensure that we make a clean and clear record. And prior to speaking, please state your name so that all the parties know who you are and who is speaking. And I ask everybody today to speak slowly, clearly, and close to your microphone. Try to limit distractions. Please turn off mobile phones and any devices and noisy things that might interfere. And as a general reminder for all us Board of Appeals members, we'll try to remember to state our name before speaking throughout our hearing. I'd now like to have the Board of Appeals members introduce themselves. Can we just go down the line, start with you, Scott?
Scott Martin.
Yeah, okay. Myself, I've already introduced myself, Kathy Lewis, Chair.
Rachel Abel.
Ooh.
Rachel Abel, Vice Chair.
And John? John, you'll have to unmute your microphone. See if you can do that.
Okay, it's unmuted. Can you hear me now? Can you hear me?
Yes, thank you.
Okay. Yes, I'm John Kimura, board member.
Thank you, John. And now will the board staff please introduce themselves?
Good morning, Bethany Morrison, board staff.
Kim Tanaka, Board Staff.
And Sylvia Wan, Deputy Corporation Counsel, Counsel for the Board.
All right, so at this point now we'll take statements from the public on items that are on the agenda. Now, this is not the time for you to testify if you're going to be called as a witness unless you want to give a different kind of a statement. You're welcome to do that. Public testifiers can testify now or prior to the agenda item that they wish to testify on. And Ms. Wan will keep time. Anybody that wants to speak will have 3 minutes. And at 2.5 minutes, Ms. Wan will announce that time so you know to wind down. Bethany, do we have any public testifiers that you know of?
We do not have any public testifiers at this time, Chair.
Okay, well, that makes that a little easier. All right, I just want to do one little housekeeping thing. Just so you know, we have 2 matters that are on the agenda that will be listed as number 1 and 2 under old business. Or no, number 1 under old business and number 2, it's listed under new business. We're going to take care of those items and then we'll be taking a break. So if you are here to participate or listen to the 3rd item on the agenda, the 3rd and 4th items on the agenda, which are matters brought by Ms. Claudia Rohr, you can wait until after the break, and that would be fine. So with that said, then we'll just go right ahead and dive into the old business. And the first case is Dwight Vicente. That's case number PL-INT-2025-011330. what we're taking up today is a proposed order that has been prepared rejecting a defective petition. At the last meeting, we voted that the petition was defective. That was our decision. Now we're just taking a look at the written order on that. And Bethany, are there any public testifiers on this one agenda item?
Chair, no public testifiers. However, Mr. Vicente is here at the
And
table.
we see that. Thank you for attending, Mr. Vicente. So we are here then to adopt or not adopt or amend the form of the order rejecting a defective petition. So I'll ask all the members of the board if they've had a chance to review that.
I'm sorry,
Yes,
Chair, can I interject just for a second?
sure.
So at this point, generally speaking, the board doesn't hear from the parties regarding the forms of the order because
True.
input would have already been provided.
Correct.
I just want to formally note for the record that Mr. Vicente has previously provided some input for this. However, because I do see him at the table, if he wants to provide some public testimony today, he could do so. Because there's this, I just want to make sure that he has the opportunity to provide public
Okay.
testimony if he wants to.
Yeah. Is that something you'd like to do, Mr. Vicente?
Yeah.
All right. So we'll treat it
Yes.
as public testimony, limit it to 3 minutes then, please. Go ahead.
Morning, my name is Dwight Vicente. I'm representing Hawaiian Kingdom under the 1840 Constitution and the 1848 Mahele, which is a land trust. And the jurisdiction question, most people don't realize, even I didn't realize till later on, like 2019. Harold Jim, State versus Harold Jim, the jurisdiction question was settled already on the ceded land only. Where I'm at, what we're dealing with today is the leased lands. Under King Kalakaua, it was leased out for 30 years. And where I'm at is Crown Lands leased out to Waiakea Sugar Company, 1890 to 1920. 1917, Waiakea Sugar Company sold those lands illegally. They didn't own them. It was under lease contract under common law as homestead. A homestead program come from the Northwest Ordinance of July 1787. That's where you'll find it. Well, even the Hawaiian Homes program. Well, in the State versus Jim, he argued both the ceded land. He said the U.S. Congress under the 1898 Joint Resolution has jurisdiction. The leased lands, 1959 State of Hawaii has jurisdiction over the leased lands and the county, which is not correct, according to history and the rule of law. So what happened was the Moon Court did not address or publish the record of what was he actually argued. I talked to him. That's how I found out about that. So they only referred back to his earlier cases, which is the Hawaiian Homes or ceded lands. So they avoided publishing that so nobody would understand what was actually dealt with. But they actually dealt with the jurisdiction question, which was limited based on the 1898 Joint Resolution and 1959 Admission Act, ceded lands only. So the state and county today cannot use the State Land Use Commission created in 1955 and the Planning Commission, which was created about that time period too, to assume jurisdiction over these leased lands, which most people refer to them as
30 seconds remaining.
agricultural lands. So King Kalakaua actually leased those lands, over 2.2 million acres of Hawaiian Kingdom Crown and government lands. The ceded lands is actually the Crown and government lands which had no lease contract over. So with that, I'll reserve my rights to, under the Queen's protest, January 17, 1893, against nefarious U.S. Minister Stevens. And that has yet to go to the U.S. Supreme Court, Article 3, Section 2, Clause 2. And since the
However, your time has expired. Thank you so much for your testimony.
All right, thank you, Mr. Vicente. So at this point, I would entertain a motion regarding the proposed order rejecting the defective petition, excuse me. Anybody have a motion?
I'll make a motion to approve the proposed order rejecting the defective petition PL INT 2025-01130 as drafted by the board's council as it reflects our decision from January 9th, 2026, unanimous vote rejecting the petition as defective under BOA rules.
And can you please, Deputy Corporation Counsel Sylvia Wan, can you please state your name for the record?
Sorry, Rachel Abel, Vice Chair.
Anybody second that?
I second.
All right. Say your name, Scott.
Scott Martin.
All right. And I'll take a roll call vote then.
Chair, on the motion to approve the proposed order rejecting the petition, Board Member Rachel Abel,
Aye.
Board Member John Kimura,
You're, Mr. Kimura, you're muted again. Now that's better.
Okay, so I is my vote.
Thank you.
Board Member Scott Martin,
Aye.
Chair Kathy Lewis,
Aye.
Chair unanimous.
Okay. Oh, we didn't have discussion. We forgot discussion. We should go back.
Yeah, that's,
We should go back. All right, we're gonna go back, excuse me. After the second, we have discussion. Does anybody wish to discuss this issue? All right, now we'll go ahead and do the vote. I'm sorry.
Okay, Chair, on the motion to approve the proposed order rejecting the petition, Board Member Rachel Abel,
Aye.
Board Member John Kimura,
Aye.
Board Member Scott Martin,
Aye.
and Chair Kathy Lewis.
Aye.
Chair, you have a unanimous.
All right, with that unanimous vote, then the matter is, the motion is passed. And let's say that again.
and the form of the order accepted.
And the form of the order as presented is accepted. Thank you for coming, Mr. Vicente. We will now move on to new business. Calling the case number 2, William Frazier. This is PL-BOA-2025-000123, paren. Oh, I guess I don't have to say paren. This is an appeal of the decision by the Director of Public Works dated July 23rd, 2025 regarding notice of unpermitted driveway in the county right-of-way. The location is Wright Road in Volcano, Hawaii, 96785, and that is TMK paren 3, close paren 1-9-003:018. Bethany, are there any public testifiers on this agenda item?
No public testifiers, Chair.
Okay, thank you. So we did this?
Yeah.
Okay, I will note that the board has also received written testimony on November 6th, 2025. May I please have the names and appearances of the parties for this matter, starting with the appellant? And that's you, yeah.
William Fraser,
All right, thank you, Mr. Frazier.
Deputy Corporation Counsel, Sinclair Solis Ferguson for the Department of Public Works, County of Hawaii.
All right, thank you. So Bethany, has Mr. Frazier provided notice of the hearing to the surrounding property owners as required by our rules and proof of service filed?
Yes, Chair, that was filed April 22nd, 2026.
All right, excellent. Then we can get back on with the hearing. I'd like both sides to know that we have read the record in this case. So keep that in mind and try not to repeat what you've already provided to us. Know that we have read it, and if either side begins to present testimony or evidence that's not relevant to the hearing today, I may interrupt you and guide you accordingly. There's one legal issue before this board, and that's whether the director's decision in question should be reversed or affirmed. And with that, we can begin. So we'll hear now any opening statements from the parties. Please keep your opening statements, if you have 1 to 10 minutes. When you're after 8 minutes with 2 minutes left, Ms. Wan will announce that for you. And we will start with you, Mr. Frazier.
All right, my appeal to the council is basically not that I do not require a driveway. My appeal is that this is not the time for a driveway,
This would not what?
the time for a paved driveway. The property in question is a vacant lot used to hold horses. I'm in the process of grubbing it and clearing it. And I haven't yet to plan to build on the property. For me to put a driveway in now would be, for lack of a better term, stupid, because I don't know where the driveway will be, right? As she stated, the address for the property is on Wright Road. The access that's there now is Old Volcano Road, right? It's around the corner, right? The access from Wright Road, I have yet to clear. I'm working my way around the corner to get to it, right? And I've been clearing for a year now, right? It takes what it takes, right? You know, I'm not saying I don't need a driveway, right? The county got the complaint from my neighbor, right? You guys have read his 20-page manifesto about everything that I supposedly have done wrong, right? There are about 2 half-truths in that whole statement. I don't know if the attorneys looked into it, but he does a lot of statements and has no facts behind it, right? He states in that manifesto that I made this driveway. I didn't make it, right? The history behind that, this whole episode is he bought his property 2 years before I bought mine. He says in his testimony that that's a half truth. He didn't move there till 6 months before I bought my property. In that 6 months, he changed the driveway on his side, right? He had an old Jeep trail and then he made it nice and built it up and blocked the road, which in turn sent water down the access that is to my place right now, flooding his property, which he states in there he's suing me for. I don't get it, but we'll sort that out when it comes to the lawsuit, right? I talked to him about it 3 times, right? He did nothing and he just left it. And then I called the county and I said, I didn't say he put a driveway in. His driveway is illegal. I said his driveway is blocking the flow of water, which is flooding my property. And if you look at the photos I gave you, you can see one of my webcam photos. There's oceans of water flowing into my property, right? I waited 4 months for the county to do something. They did nothing, right? Then he finally got his citation for his driveway, for an illegal driveway, which I didn't get, right? And he paved over it and he put exactly the same driveway in, right? At that point, I decided I needed to raise my property where this access is on Volcano Road. And I raised it up 6 inches to be higher than the center of the road, right? And it looks like, by the picture, that I made a driveway. I took my gravel and I pushed it up and made a peak to keep the water out. And I placed photos in last week or 3 weeks ago showing the March 14th storm. It should be in your computers, where what I raised stops the water from coming in my property. And if you look down the road, his driveway is still blocking the flow of water. It backs it up to the point that it almost goes to the middle of the road. I never once made a driveway. My intent is not to use it as a driveway. Yes, it is the access to the property because that's all I have. It's not a residential property. And if you look at the permit, it has 2 blocks, residential, commercial. It has nothing for agricultural, right? The only thing that lives on this property are 2 horses. And the only time I need that access is when I can't use the main access, which I use, which is a gate between the properties. I own the property above. My parents own the property above, and we have an access in between. I use that 99.9% of the time. Again, in Mr. Lassard's manifesto, he says I frequently use the access. But if you look at this manifesto, there's 25 photos or 20 photos in here Not one of them shows me using it for vehicle access or having parties as a parking lot or cars coming and going, right? His word frequently, I use it about as frequently as there are truths in this piece of paper, which is probably once every 2 or 3 months when I have a piece of equipment that I can't get in normally, right? I put a gate up to protect my horses. I put a front on it, right? I might as well make it nice if I'm gonna put a gate, right? And my mother plants flowers on the outside of my property. There's nothing against that. But if you go look at it now, there is no driveway. I have not connected to the county road. I had no intention of doing it, right? You know. The other point I have is the county says I have to follow the what is that? The application for the permits. And if you look in there, it has all these measurements for keeping stuff off the driveway. I'm supposed to follow this. The plaintiff, Mr. Lassard, has followed nothing, right? He put his new driveway in, permitted by the county. It is within, it's crosses over onto my property, right? The flares. I put in a complaint about that. They asked him to scrape it back, right? He paved up to 6 foot to the property line because that's what he's supposed to, and then he put gravel down, right? And I complained about that, and they just asked him to scrape it off the road. They took the gravel and he scraped it 6 inches off the road. I provided the photos for that, right? So now his gravel driveway isn't a driveway. If you look at the photos I provided, where is it?
Sorry, just want to object right here. I think we should focus on your driveway. The appeal is not about your neighbor's
I
driveway. So
understood. But if I'm being held.
Okay, wait until I rule on that objection. That's just how we do
Sorry.
it. I do agree that some of this is irrelevant, to the extent that you're explaining that it's not a driveway and why it's not a driveway, that's relevant.
Okay.
But, his driveway and that has to be a different
Okay, understood.
matter.
I
Thank
can
you so
live with
much.
that, but
Anything
There you
else?
go. That's pretty much it.
Okay,
I haven't put it in, right? I don't use it as a driveway per se, right? As any other piece of land, if there's a place to get it on, that's where you would drive, right? It's agricultural, horses live on it, that's it. If you look on the building permits, when you go to put in your house building permit, and I built a few houses, right on the front, it's stamped when you have to put in a building permit, drive access permit. That's when you should have to put in an access. Just because you're clearing land and horses or animals live on it, I shouldn't have to put in a concrete driveway because depending on the weather conditions and the rain and how it's graded, when it gets graded, should it ever be graded, that hole might change, right? I'm not done grubbing, and now I'm supposed to put in a driveway. And I'm not asking you to tell me I don't need a driveway. I'm asking you to wait until that point, is all I'm asking. That's it for me.
thank you. Thank you, Mr. Frazier. Mr. Salas Ferguson?
you know, there's laws and, some people don't agree with laws and that's fine, but we all have to follow the laws as they are, even if we disagree with them. Sometimes I would like to go faster than 35 miles per hour, but I have to follow that 35 mile per hour rule because it's a law. And the law in this case, it's really simple. No county street shall be used for ingress or egress to a property without a properly located and constructed driveway approach. He just mentioned, he's mentioned in the pleadings, he's mentioned here on the record that he does use that for ingress and egress to his property. I think he said 99.9% of the time he's using his parents' property, but multiple times in his statement, he said on the record that he does use it to access his property. So if you're using it for ingress and egress to your property, you have to get a permit, and you have to comply with the specifications and requirements that Public Works has for these driveway approaches. So it's very simple. If you're gonna use a county road for ingress and egress to your property, you have to get a permit, and that's what this case is about. You got to get a permit. He didn't get one, and we're asking that the board approve the department's decision to require that he get a permit.
All right, thank you for your statements. And now we'll proceed to present witnesses. Mr. Frazier, do you have any witnesses that you'll be questioning?
No, I don't.
Do you wish to question the is the director here? Is anybody here?
So, Chair, that statement that he made is not evidence, it's just a statement.
Right. Do
So
you want, I know you'll have a chance to question him, obviously.
if he decides to testify in his chief in case. So
Right,
if he
true.
doesn't want to testify, I'm
Yeah,
okay
he
with that
doesn't.
too.
Right.
So I guess the question is to you, Mr. Frazier. Would you like to testify on your own behalf in this hearing to present the evidence for this particular case? Because what you just did was an opening statement, which is argument. So that is not considered evidence in and of itself. So if you have evidence that you would like to present to the board, now would be the time.
And you have to be sworn in, and that's
So
kind of the difference in a way.
yes, and I would swear you in if you choose to do that.
And then what happens is you don't have to repeat yourself too much. We're going to keep it to facts, things like that. And then the board also might ask you some questions.
I assume there was a engineer from the county that was coming. I had questions
Is
for her.
somebody, nobody is coming from the county?
That was on the original witness.
We have a witness,
Okay.
but it's their burden to disprove.
Right.
So we'll
So-
let him present whatever he wants.
Mr. Frazier, you can question the county's witness. Once the county questions them, then you can cross-examine that person.
Yeah, I'll wait for that.
Okay,
I've said my piece. I've put it in my papers.
all right.
But I'm just going to let you know, as far as the legal standards go, your argument is not evidence. So if there's evidence that you want to present, and I do know that everything that you submitted as far as documentation, that is considered already evidence for the board. And so if you want to just rely on that documentation that you provided, then that's fine. I just want to make sure you're clear on your choice.
Yeah, I have nothing to testify. I have everything
Okay.
there, and as he said, it is what it is.
Okay,
But
so I'm
I
just,
do have questions for his witness because, right?
Does
if I'm
anybody
gonna be held to a piece
on
of
the
paper,
board wish to
the county needs to be held to the same
question
piece of
Mr.
paper.
Frazier? Okay. All right. Well, we'll go ahead then with the first witness then that you may have, Mr. Salas Ferguson.
before we go on to the department, I just want to note for the record that Mr. Frazier has waived his right to present witnesses for this particular hearing. Thank you.
Okay. Do you wish to present a witness, Mr. Salas Ferguson?
Sure. I was thinking of just making anyway, I will call Melanie DeMello. She's the deputy division chief of the Department of Public Works Engineering Division. And what is the setup in here? It's
Good
kind
question.
of odd. I think we should think
Where
about
would a
that.
witness go?
Maybe up here.
I see you have two laptops. Do you want to go around the side and have your witness in between?
Between me and Mr. Frazier.
Yeah, if you think that's comfortable, or we can actually let's put the witness on the side. It's just, I need the microphone to be able to catch both of you.
Can we have the witness up there?
We would have to change the view of our feed. Okay, if you can give us a moment, can we take a
Yeah, let's take
standing
a break.
recess, Chair?
Sure. We'll take a little bit of a recess, just a few minutes, and get set up for a witness. Thank you.
Can you do it to the one right next to Rachel?
I do have one question, so I'm glad he's putting some.
Not this one, but the next one, yeah. And can we zoom back in to this plus Rachel?
And then show her how to turn her mic on.
Perfect. Wonderful. Well, yeah, let's not, there we go. Perfect. Okay, Chair, I believe we are ready to proceed with the hearing.
Okay, we swear in the witness, Ms. Warren.
Yes. Can you please state your name for the record?
Melanie DiMello, Deputy Chief for Engineering Division.
Thank you. Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth before the board today?
Yes.
Thank you. You may proceed.
Before I question the witness, I'd like to move into evidence the record on appeal under Board of Appeals Rule 3-13H.
Motion granted.
Melanie, I'm just going to ask a few questions. There's been no evidence presented by the appellant, so all the evidence presented today is going to be the record on appeal and your testimony. Are you familiar with this case, William Frazier, with the property located at TMK 31-9-003-018?
Yes, I am.
And was there a complaint filed in this matter?
Yes, we received a complaint filed with our office.
What was the allegation in the complaint?
There were a number of complaints listed, but the one we're here for today, which is included in the complaint, was an unpermitted driveway.
You'll need to, I need both of you to speak up a little bit
Okay.
better for me.
Sure. So an unpermitted driveway was one of the complaints filed with our office.
So, County Department of Public Works Engineering Division received a complaint for an unpermitted driveway, which was routed to the Engineering Division because the Engineering Division handles complaints of unpermitted driveways. Is that right?
That's correct.
And once your division receives a complaint, what do you guys do?
Once we receive a complaint, it's routed to our regulatory section, and we have an inspector go out to investigate, make a report. If it's found that there is a violation of county code, then a notice of violation is issued to that property owner.
Was an investigation conducted in this matter?
Yes.
And was there a violation found for an unpermitted driveway?
Yes.
What happens after a violation is found?
So after the violation is found, the notice of violation letter is mailed to the property owner. Basically, it states what the violation is, what section of the county code is violated, and what the remedy is. There gives a timeline. It can be followed up with an order after that.
So the notice basically informs them under Hawaii County Code, they're required to get a permit to have a driveway to access their property ingress and egress using a county street.
Yeah, that's correct.
And then I just want to, I know it's already in the record, but I'm just going to bring it up to you and just the record on appeal for documents 1 through 3. Is that okay, Chair? So this is just, did you receive a copy of the record on appeal? Yeah, so it's just the complaint, the investigation, and then the notice of violation. Okay.
Yeah.
So Melanie, document 1 is a copy of the complaint that was filed in this matter, right?
That's correct.
Document 2 is a copy of the investigation finding that there was an unpermitted driveway, correct?
Yes.
And then document 3 is just a copy of the notice of violation
Yes.
for this matter. No further questions.
Okay, do any board members have questions of this witness? I do have one question. Under the rules that you're enforcing here and the laws, is there a requirement for how long the driveway has to be?
Long, Into the, you're
I'm
asking-
assuming there's a width, but what about how far in it has to go from the road?
Our regulation is within the county right of way, so we wouldn't regulate, I guess, length in the private property. There's just a requirement that for the portion that is within the county's property, the county right of way, the connection to the road, that there are certain standards that have to be met and the permit has to be pulled for that.
So in other words, to satisfy what's being required, he doesn't have to create a driveway going to some unknown building. He can just enough for him to get into the property then.
That would be correct. Our regulation would just be the connection from the county road to the edge of the county's property.
Do you
Into
know
his
roughly
property.
how long that is?
I don't have that exact number offhand. Yeah, I don't have an exact number for this case.
Even a ballpark kind of a,
I guess if you look
range?
at the photos. I guess if you were to look at the photo in document 3.
I don't want you to speculate, don't speculate.
Right, yeah, I guess all I'll say is if you look at the photo in document 3, you can see a gate and you can see the edge of the county's
Okay.
paved roadway. That would give you an idea of
Okay,
the area we're talking
all
about.
right, thank you.
So that would make the minimum requirement for him to be legal?
Yes, if you pulled the permit, it would just be for that section. Beyond that, in his private property would not be part of the county permit.
So the financial impact is not going to be to put in an entire driveway into an unknown, into a location where he doesn't know where his ultimate residence is gonna be.
We wouldn't be regulating within his private property in regard to the driveway.
Okay, so less of an impact then.
Speak a little louder into the microphone.
Then it's less of an impact to him financially.
Well, I think we can
Okay.
agree with that one. All right, Mr. Frazier, would you like to cross-examine this witness or?
Sorry, Chair.
Yeah, and you keep it to the confines of what she's already testified to. So, basically you're addressing what she said so far. That's fair game. So go right ahead. I'm sorry. Oh, I'm so sorry. Wait, we have one more question from the board. Sorry, Beth.
Sorry. I just wanted to ask, did you provide proper notice and an opportunity to cure the situation before issuing the unpermitted driveway notice?
As far as you said proper notice to the
the
property. Our process would involve, the notice would be the mechanism we use to notify them of the violation.
Just say that again, please.
Providing the notice of violation would be what we provide to the to the violator. I'm not sure if I'm answering the question correctly.
It's a yes or no answer. I
If-
think. You
if
go ahead and
you're
ask the question again, Rach.
For clarity, what I'm trying to understand, was he given the opportunity?
Yeah, get these microphones really close.
What I'm trying to clarify, if he was given the opportunity to fix the situation prior to issuing the notice of the unpermitted driveway.
Yes, in that the notice, I believe, gives you 30 days to correct the violation.
Okay.
But the notice doesn't indicate a particular cure. Only the time period that he's got to fix. It doesn't suggest that build a small little piece of driveway that technically meets the requirement.
Yeah, well, what it says is to apply for a county right-of-way permit in the notice.
But then it's up to the plaintiff,
And
the appellant, to figure out what the cure is.
we do provide our contact information, so, if there are questions, it states that, you can contact the department for the code requirements.
Go ahead now. Yeah, go ahead. Yeah.
Mr. Frazier, just wanted to ask if you participated in that process after they gave you notice.
Can we swear him in if he's gonna
Yeah,
be a
yeah, we
witness?
better.
And also,
You're right. We'll swear him in and we'll do that. We'll-
I would object to this because I'm not calling him as a witness. He's already rested his case. And I would like to ask some follow-up questions based on what you guys are asking.
You can ask your follow-up questions, but I will give him a chance because he is pro se to go ahead and, since there's new issues that we've raised, actually, so go ahead. Go ahead, Mr. Freaks.
Can I swear him in first?
No, we're gonna, he
No,
wants,
Mr. Frazier is a because you're asking him a question.
no, he wants to finish with his witness now. He wants to ask further questions of his own witness now.
Sinclair wants to ask further
Yeah.
questions of his witness. That is correct. Vice Chair Abel would like to ask a question of Mr. Frazier.
Right, I was gonna leave that until he was done with her.
So maybe
Okay, I'm sorry. I was unclear. So my understanding is now we're switching to the
Okay.
department is going to continue with their witness.
Exactly.
So this is just when you guys ask questions, and I want to be able to follow up some questions on that. So
You got a question?
yes,
Okay.
it's a question. So people are required to get a permit because that driveway portion is going to be on the county right of way, correct?
That's correct.
So there's the county roadway, which is pavement.
Well,
right?
you're leading. I'd say try not to lead quite as much.
That would be an objection from them.
Well, I'm also just asking you not to lead your witness as much. You can do it.
the when a county owns a roadway, is there a portion that's paved and a portion that's not?
Yes, that is the case in some instances, such as this one.
Okay, so the part that's paved, what do we call that?
I would call that the county road.
And then the portion of property that we own that's not paved, what is that called?
It's part of the county right of way or county property.
So that's county property.
Yes.
And in order to do work within that right of way, which is county property, you have to get a permit, right?
Yes, there is a work within the county right of way permit that's required
To install a driveway.
to install the driveway as well as any other excavation type of work. Yes.
And for the engineering division for driveway right of way, you guys, are you concerned with what they do on private property? Do they need a permit to to do a driveway?
They would not need this permit for work on private property.
Okay, so that's my follow-up to the board's questions earlier.
Okay, appreciate it. All right, you may, unless anybody.
But on the county right of way that he wants that he may end up doing some work on, he would need a permit for that.
Yes, that's correct.
Okay.
Any further questions of this witness? Any cross-examination?
Sorry, I have one more follow-up based on the question from the board member over here.
Go right ahead.
So when somebody is, for example, if somebody does work in the county right away, how does the department notify them that that they're doing unauthorized work in the right of way?
When we receive a complaint, if there is a violation and there's unpermitted work being done in the right of way, we send them the notice of violation, like what's in document number 3.
And the notice of violation tells them, does it tell them what the violation was?
Yes.
Does it tell them how they can cure that violation?
Yes.
And in this case, what's the cure for the violation?
The stated cure is to apply for a permit with our office.
Okay, no further questions. Thank you.
All right, thank you. Mr. Frazier, do you have any cross-examination of the witness? Go right ahead.
What is the process when a landowner buys a piece of raw property? As far as when do you have to get a driveway put in? That's what I'm trying to say, right? I buy a piece of property, there is no access, right?
Mhm.
So at what point do you figure that out? Or what is the time limit before I have to get a permit?
Objection, vague. I'm not sure what facts we're talking about. Property is super broad. It's a speculative hypothetical.
All right, when a landowner
I-
buys a piece of
I'm,
property,
I'm going to sustain that, but I do think you can get to your point if you ask the question very specifically
all right,
for
Eh.
you.
for a piece of agricultural land, right? What is the permit that I'm required to? Because the permit we have here says commercial and residential, doesn't say agricultural.
So in chapter, as far as chapter 22, it doesn't, land use is not a consideration. The code states that any ingress or egress to a property must have a properly constructed driveway approach. It doesn't mention land use.
And when you buy a piece of property, at what point do you have to apply for a permit?
I would make the same statement that, if you're using it for ingress and egress, regardless of what's on the property or when it was purchased, you would need a properly constructed driveway approach.
Okay, good. If you go to, I have examples of driveways, I think it is. Nope, not that one, sorry. Where was it? We'll get to that one in a minute. I had it. Yeah. Access photos with captions is the, wasn't even that, sorry. Where'd it go? I didn't bring it today. All right. So every driveway that is made has to follow this form, right? The permit form.
If there's work being done in a county right of way.
All right. And it has the drawings attached, right? It's DR 37, DR or R 38, R, and it goes on and on. My interest right now is the R 38, the drawing for the driveways. It gives you all the dimensions. You don't have it up there. I can give you this one, and if you can explain what the numbers on this drawing mean, and that if everyone has to follow this form, right?
Objection, I'm not sure there's a question
I'm
in
not
there.
sure either. Do you?
I don't understand this form, and I would like her
Okay.
to tell me it. Right?
Well, I don't think that's probably relevant to what we're doing now. You could certainly talk to
Yeah.
the planning people.
Oh,
outside of
understood,
it
but you know,
to get
they're
that.
telling me I have to follow this form, right? And right, I have an example of where none of this is being followed, but yet I have to follow it, and it happens to be their star complaint witness, right? The guy who filed the complaint.
I'm not really following it, but we have testimony and now on record that says
Yeah.
the amount of driveway you need to provide.
Yeah,
So
understood.
that's about all we're gonna take it, you know.
Okay, all right.
I think getting into.
Okay, I'm
weeds-
gonna ask one more question.
Yeah, okay.
Can I make it temporary out of gravel? Can I make a driveway temporary out of gravel until I've decided? Or can someone make a temporary gravel driveway until they've decided where they're gonna put the driveway? If they're in the middle of, let's say, grubbing or, right?
The permit we're talking about, and again, for the connection within the county right of way is required to be paved. What you do in your private property would not be subject of this permit.
And how many driveways are you allowed, how many times can you apply for this permit per property? So
What you,
how many accesses are you allowed to have?
Objection, not relevant.
Yeah, that's not
Yes.
relevant.
Well,
right?
if I put in the first one
Well,
and I
this-
want
this
two
would-
more, right?
That's not the subject of this particular situation.
I'm trying to not put in a driveway so that I don't use it up, right?
I
If put a
understand.
Driveway in where it doesn't belong.
Understand what you're saying, but you're gonna have to work with them beyond the confines of this hearing
Okay,
on
all
that
right.
kind of stuff. Okay. Any more questions for her?
That's
Okay,
pretty much
well,
it.
thank you.
Yeah.
All right, you can step down.
A quick redirect.
Yeah, that might, yeah. Oh, I'm sorry. Yeah, did you want to redirect? I'm
I
sorry.
did. I just wanna,
I'm so sorry.
that's okay. So really what we're dealing with is that when somebody wants to use the county right away and do work in the county right away, which is county property, they have to abide by county rule and specifications for that work. Is that right?
Yes, that's correct.
No further questions.
May I have one more then?
Yes,
In the investigation of my driveway, did I do any work in the county right away?
The inspector found evidence that there was a cinder driveway within the county right of way.
Yeah.
And
Can you show me where he wrote that? 'Cause I didn't get that.
Objection. That's not a question.
can you show us where he wrote, where,
It's
where
in
in the
evidence.
complaint does it
This is
talk
the
about? that?
argument. So it's in evidence. It says right here on document 2, which is the, document 2 is the investigation report form. It says right there, unpermitted driveway, violations found. It's
Okay.
checked off and it's written.
Yes, but it doesn't say I did anything. I did not touch the county access.
You can make that argument in your closing.
Yeah, you can argue, you're gonna have a chance to make a short closing argument. But you bring up a question, so I'm going to ask the witness a question. Does it matter when you go out to investigate? Are you concerned with who placed whatever was on the county right of way, if it was prior to the present owner?
I would say our violations run with the property. So yeah, not necessarily making statement as to who in particular constructed it, it runs with the property.
Okay. Any follow-up? Okay, all right, thank you so much. You can step down. All right, any further witness?
Can I ask Mr. Frazier a question? Do I understand correctly that there's another ingress egress to your property that you use other than the one that's in dispute today?
There are two properties. I own them both. Well, my parents own one. I own the one in question.
Right.
There's a gate in between that I use for everything other than like when I brought the pictures he provided shows the grubbing equipment. There's no way I could get that through the gate. That's where it comes through there, right? Where they came from the road, right?
Okay.
Right.
So
Or
there is no other point of entrance to your property that you can use that does not infringe upon the county road.
I do use one, but it's not big enough for, it's, for, let's say, the excavators I had in there to do the initial grubbing. They couldn't go through there.
So
they
you
wouldn't make
you
it.
can't use that going forward.
I do use it every day. I mean, normally, yes, but except for when I have something that doesn't fit. Let's say, for example, when this last storm, I cut down trees, right?
Right.
Because they were falling down and I needed to get in a chipper, right? The
Right.
chipper wouldn't fit through my normal access and the road right there will cut in and
So
go
you
through.
can't enlarge that access to use that consistently versus the,
I mean, yeah, I could.
All right,
mean,
I'm
I-
getting into
different
irrelevant
for you.
territory
Yeah.
here, Scott.
okay.
I could, but yeah, this is not for it.
You do? Okay, Rachel has another question. Yep.
I wanted to ask, I just wanted to, ask you because my understanding in your filing on August 8th of 2025, you admitted that you added the red cinder to the driveway,
Not to the driveway.
to the approach.
On my property, right? The water would roll in, right?
Mhm.
From the county access, the county ditch, because of the other guy blocking his, right? It would back it up onto my property. So I put, if you look at one of the photos, you'll see I put, because it was storming,
Mhm.
I put red cinder in on my side of the county right of way, right? Where there was in the county right of way, I couldn't tell you, but I put a berm probably 2 feet high and I left it there until had enough cinder and stuff to build up my property, right? And I pushed that back into my property when I built it up before I put the gate in, which you see in the photos. I didn't work on the county right away. I had to put a berm there because the water was coming in, right? And then I took that cinder and I pushed it back up onto my property when I built up the access where there's a berm on my property, and I built that up another 8 inches to keep the water coming from the county ditch, right? Which is the major problem, which is why I was working in that area, right?
Mhm.
I didn't build a driveway. I didn't try to connect to the county ditch. I didn't, right? Not
Okay.
my thing.
Okay. All right. I'm going to allow closing statements.
I'm sorry, do you want to ask the department if they have any other witnesses?
I think you told me they did.
No questions based on the questions you asked of Mr. Frazier, and no further witnesses.
Thank you. Okay. All right. Well, we'll have closing statements at this point. You are allowed 10 minutes. You don't need to use it all if you don't need to. But we will start with you, Mr. Frazier. And as we've done before, Ms. Wan will give you a warning if you're getting close to your time.
All right. First, I appreciate you guys taking the time, and I'm sorry if I stepped on anybody or don't know the process, right?
You're doing fine.
I'll say it again. I know I need a driveway. I know I need the permit. All I'm saying is it's not the time, right? I don't, you know, I use this land for my horses, right? And that's it, right? The complaint that was put in was retaliation because I put in a complaint about his because he was flooding my property and in turn flooding his property, but that's a whole nother story, right? I wish to have the time to complete grubbing my property, right? Before I'm made to put in a driveway. As he asked, I only have to put in, it's like 5 feet, but I have to put down concrete, right? So I'm gonna put concrete in an area that I don't think I'm gonna use. My driveway is probably gonna go 100 feet to the south. Or it could come out where it's supposed to be on Wright Road, but I haven't cleared that far yet, right? But I have to be able to clear my property and figure out which way the water goes, where I'm gonna put the rain before I put in a driveway. If I buy a piece of land, raw land, and the minute I come off the county road, that's where the driveway has to be, that's pretty dangerous. That sets a dangerous precedent. I could fall into a 10-foot ditch when I could have made it 20 feet down the road, right? They say I need this. Yeah, there's obviously a time period, right? There's obviously, when you put in your house permit, on the house permit, you have your plan, you've got your property figured out where the house goes. On the house permit, it says you need to put in a permit for a driveway. It doesn't say it when you buy the property, right? And how you can blindly put in a driveway just because that was the access, and that access was there. That access was there since 2002. I've been in Volcano 20 years. I've been watching that property, right? It's not like I put it in there, right? You know, but that's the only way for me to get in to make the property worth using, right? If you buy a piece of forested land somewhere and the minute you drive your car off the road, the state's behind you going, or the county is saying that's where your driveway is, and you haven't even cleared it yet. You haven't seen what the water or the environment is, or where you'd like to put your house, or where you'd like to put whatever, your Kubota or whatever, right? You know, and I just have to put it in now because a neighbor is mad at me because I told him his driveway is blocking the water and flooding my property. It's not fair, right? And the laws are fair. He said speeding, right? Even the cops will give you 5 miles over the speed limit, right? If you're doing 50 and a 35, they're going to hit you. But if you're doing 37, right, they give you a little bit of leeway, right? I'm not asking you to say the law is irrelevant. I know it's there. I'm asking you to give me the time to decide where I want to put that driveway. And a question I asked her, you get 2 driveways, right? You can have 2 accesses to your property. So if the first place you stepped off the road, that's it. You get one more chance to put it in and it has to stay there, right? And just because there's a complaint, right? If you read the complaints from the plaintiff, there's 5 or 6 complaints in there. The guy just won't quit, right? He doesn't like the fact that I bought the property. He doesn't like the fact that I'm grubbing. He doesn't like the fact that I had to take down the trees, right? And therefore he's complaining. He continues to complain. And he's put a lawsuit on me, right? What he doesn't tell you is I put a lawsuit back on him for all the false statements he's put out on me against the county, whatever, right? So this is bigger than just a driveway, right? And the fact that the county can't see that I deserve the time to decide where to put my driveway is. That's why I'm here. And originally I thought this was to talk to the next level of engineers, the appeal, but it turns out to be this, right? And it is what it is. And that's all I can say. This is my plea to not say I don't need a driveway, to give me the time to put it in the right place, right? How long that time is, you can decide, right? I would prefer that when I decide to build a structure and turn it into either a residential or commercial property is when I require a driveway, right? Because the access is there. It's honestly a gate 30 feet back from the property line that, yes, I would be lying to tell you I don't use it, and I don't lie, right? I do use it occasionally, right? Like people pull off the side of the road into the county right of way occasionally. You don't get tickets for that, right? Now, if I use it every day, that's one thing. But again, if you look at the manifesto from the complaint, out of the 20 pictures in there, there's not one where vehicles are coming and going. He says in there, I use it frequently. Well, frequently is once every 6 months, once every 3 months. I'll give you that. You know, it's not an everyday thing. It is not the primary access. It's not, I'm running in and out every day, right? And cars pull over on the side of the road all the time to use the county right of way, right? When it's not paved, right? Trucks go on the side all the time, right? The county uses it all the time, right? I'm not damaging the road. I don't plan on damaging it. If I damage the road, I'll have to fix it, right? And when I'm ready to do a driveway and I know where it needs to be, I will put in the permit and I will do it right. And I swear to that on my honor, right? Uh, That's all I have to say, right?
Thank you, Mr. Frazier. Okay, Mr. Salas Ferguson.
I'd like to redirect the conversation to the authority that the board does have. A lot of what Mr. Frazier is asking for the board, the board doesn't, administer permits and issue permits. Sorry, a lot of what Mr. Frazier is asking for is not under the authority of the Board of Appeals. The Board of Appeals is an appellate body that looks at whether a director erred in their decision and such. It's a high standard, whether they violated code or law, whether it was an abuse of discretion. The board doesn't have the authority to give Mr. Frazier a break on the law that applies to every property owner. Whenever anybody buys property, they conduct due diligence, right? They look at the property, they determine what they're going to use the property for, they research all the applicable laws, and then they move forward or they don't move forward. Maybe they buy a piece of property and it has some issues that they can't afford at the time. They deal with it like every other property owner. Maybe they sell the property, maybe they take a loan and do what they need to do. But those are matters, those are private matters that a private landowner has to consider on their own. The county the Department of Public Works interest is in enforcing the law. And the law for this situation is that when you're using county property to access your property, your private property, you have to follow county rules. And that's what this is. And the notice of violation, there was no evidence in this case that the notice of violation was clearly erroneous, violated any code or applicable law, or was arbitrary or capricious or an abuse of discretion. It was actually an affirmative thing that the county had to do. They got a complaint, they had to investigate it, and they had to treat Mr. Frazier just like they treat any other private property owner. And they issued the notice of violation, informing Mr. Frazier that to use the county right of way to access your property, you have to apply for a permit. And that's what we're here today for the Board of Appeals to make a decision whether or not the county clearly erred when they issued that notice of violation. And I would argue no, they were actually required to issue that notice of violation. Did the notice of violation violate the code or other applicable law? No, there's no evidence of that, not even an argument of that. And was the notice of violation clear abuse of discretion? No, it wasn't an abuse of discretion. It's something that they had to do. For a lot of Mr. Frazier's other questions and concerns and everything else, he can have those discussions with the Department of Public Works, but not with this body. This body doesn't supervise the Department of Public Works. You can't direct the Department of Public Works to give people breaks. You're only looking at whether or not that decision violated one of those standards. And I think based on the evidence that was presented, there was no evidence presented by Mr. Frazier aside from a few questions that he answered from the board. All of the evidence today, the record on appeal, the testimony from Melanie DeMello, is that the county is following the law and did not abuse its discretion. And we'd ask that the Board of Appeals affirm the Department of Public Works decision, which is the notice of violation in this matter. Thank you.
Okay, thank you. And now we'll close the taking of evidence and argument in this matter. And the board will begin to deliberate on its decision, and we need to start that discussion with some motion. So I would entertain a motion on this matter.
I motion to discuss.
Sorry,
you-
you would, Deputy Corporation Counsel Sylvia Wan. As far as a motion to initiate discussion, the motion would have to be approve or otherwise move to,
You
sorry,
would move to affirm, deny, or, you know,
or remand
Yeah.
with instruction. Yes.
and then we can. So do you want to do that?
And I'll just note that if the board needs a little bit of time to try to formulate a motion, you're more than free to request a recess from the chair.
Rachel Abel, Vice Chair. I make a motion to affirm the director's decision in PLBOA 2025-0000123. The decision was not erroneous, arbitrary, or capricious. Based on the meeting today, the director based the notice on undisputed facts that the appellant placed the unpermitted material in the county right of way, and also that he was using that driveway for access purposes.
Second.
All right, and now we have a second and a motion to affirm. I will entertain discussion from the board members.
I'm not hearing any discussion presently. By the way, this is Deputy Corporation Counsel Sylvia Wan. Vice Chair Abel, would you be willing to provide a sentence or two to support your motion as to your thoughts behind the motion?
I think she just did.
Yes. Go ahead.
Rachel Abel, Vice Chair. The statement supporting that, I would say that the appellant did openly note that he did add the cinder to the driveway, either for access or for to deter his own property from being degraded in the event of a nature event. And also the fact that he stated that he is using the driveway, which crosses over the county lines to access his property, and doing that without proper permits.
Okay, any discussion? Mr. Kimura, any discussion? If so, you'd have to unmute your mic, but I'm not saying you need to, I just want to make sure and invite you to do that. Okay, you're muted. Okay, all right. Well, hearing no discussion then, I guess the motion is to affirm the Director of Public Works decision and notice of violation in this matter. We'll take a roll call vote then.
Thank you, Chair. On the motion to affirm the Public Works Director decision, Board Member Rachel Abel,
Aye.
Board Member John Kimura,
Aye.
Board Member Scott Martin,
Aye.
Chair Kathy Lewis.
Aye.
Chair, you have a unanimous vote.
Thank you. All right, on that unanimous vote then, Mr. Salas Ferguson, will you prepare an order for us? And I do thank you very much for your efforts today and your honesty in front of us. We appreciate that, and I wish you good luck in this.
I appreciate your guys' time and thank you.
Deputy Corporation Counsel Sylvia One, I'm just going to note for the parties, as directed by the chair, the prevailing party, which would be the department in this matter, is requested to please provide to the board a form of the findings of fact, conclusions of law, and order in this matter. The due date would be June 5th, 2026, and the opposing party or the non-prevailing party, which would be you, Mr. Frazier, can provide any objections and or comments to that form of the order, and that would be due on June 22nd of 2026.
So he's gonna prepare.
So he's going to prepare a form of the order.
Yeah.
You'll be able to review it, and you're being given some time to be able to provide any written objections
Okay.
or comments.
All right. All right.
Thank you.
Thank you very much.
All right, thank you so much. And at this point, we're going to take a aren't we?
We do need to take a recess.
All right, then we're going to take. Sorry, I turned my mic off. We're going to take a 15-minute break and come back and take up the next two matters on the agenda. Thank you.
So Deputy Corporation Counsel Sylvia One, I'll just note for the record that it is 10:46. The board will return at 11:01. Thank you.
Please check your email for my memorandum, Chair. Madam Chair, can you hear me? It's Claudia.
I can hear you.
Please check your email for my draft memorandum in opposition. I sent it to everyone, but the county's Epic system isn't letting me load it for case 191, but they let me load it for case 121. But I emailed it to all the parties. Sorry. You can call me on my phone if someone would call me.
Ms. Rohr, can you hear me? Ms. Rohr, can you unmute your mic and let me know if you can hear me?
Yes, I can hear you.
Okay. And are you going to be turning on your camera?
Yes, I will.
Okay.
I'm
We're going to
just-
start. I just wanted to let you know that in the meantime, we have received your memorandum. And after we do some preliminary things, the board will take the time and read it for themselves since you've provided it for us. So
I was
we'll-
going to ask them to read along and I will read it.
well, there's no need for that now because you've given it to us ahead of time. So we'll just read it and we'll let you know when we're done reading it and we'll let you know when we're going to read it. So we're going to start now then by calling.
Sorry, Chair, can I just confirm, Board Member John Kimura, I emailed you this memorandum. Please check your email and let me know that you received it.
You'll have to unmute your mic if you want to speak to us. What is this?
Okay, I will do that. Thank you.
All right, so I call the meeting back to order at 11:03. And before we move on to the next two cases, I'd like to provide just some quick reminders on protocol during this Zoom, because we have Zoom participants. So if you have not done so already, please turn off mobile phones and any other devices that might make noise or be distracting. And for those of you in front of a laptop or a phone by appearing by Zoom, your cameras must be turned on at all times during the hearing. Is that going on? Do we have?
Deputy Corporation Counsel Sylvia Wan. So I'm just going to note for the record that we do have appearing in our Zoom feed a image of the council chambers, which includes board members Rachel Abel, Kathy Lewis, as well as myself, Deputy Corporation Counsel Sylvia Wan, and member Scott Martin in the view plane. We also have an individual view plane of the chair, Kathy Lewis. We also have a view plane of the appellee, who is yet to be announced. We have board member John Kimura appearing by Zoom, a landowner, Mr. Stranke, and I'm sorry if I'm saying your name incorrectly, for cases number 3 and 4. Myself is not in the view plane, as I am already currently in the view plane within the chambers image. And we have Miss Rohr, the appellant, who's present, but not, her camera is not on. And I'm sure we will request that camera to be turned on once her cases are called.
Okay, thank you.
I'm trying to get, pardon me for a moment. I just need a breath.
I'm going to keep talking at this point, so you won't need to speak yet. Please mute your microphone if you're not speaking to improve audio quality. Raise your hand and wait for recognition by me before speaking. Prior to speaking, please state your name so that all parties know who is speaking. And we will all try to speak slowly, clearly, and be close to your microphones. As you've already seen this morning, I have trouble hearing, so it's very much appreciated if everybody stick close to your microphone. And we'll try to have this so that one person speaks at a time, no side conversations, either here in chambers or at home with your Zoom or wherever you may be. And all of these procedures ensure that there is a clear recording and a transcript of what is being said. It may be worth mentioning a transcript is available from Zoom afterwards.
Deputy Corporation Counsel Sylvia
Yeah.
Wan. I'll just also note for the record that for those participants who are appearing by Zoom, you can request a copy of the Zoom applications transcript prior to you closing out this particular session. So at the end of this meeting, before you close your application, wherever you may be appearing, you can save a copy of the Zoom applications transcript. Thank you.
Thank you. That was actually what I was wanting to clarify. All right, then we are ready then for you to turn your camera on, Ms. Rohr. We're going to call your first case. It is the case of Claudia Rohr. That is case number PLBOA-2025-000119. And this is an appeal of a decision by the planning director dated April 11th, 2025, regarding special management area, which may be referred to as SMA, a use permit assessment application, which is numbered PL-SAA-2025-000280, exemption. Okay, a use permit assessment exemption with that number. The location of the property at issue is 14 Oe Street, Hilo, Hawaii 96720. At this time, Bethany, will you let me know if there are any public testifiers on this agenda item?
Chair, we have no public testifiers.
Thank you so much. All right, now, it's in this case, as you know, we have before us a motion to dismiss filed by the planning director. And before we take up the case in chief, as we are required by jurisprudential law, we need to take up the motion to dismiss first. And so, before we get into arguments on the motion to dismiss, will the board please take a moment and let me know when you're done to read Ms. Rohr's position statement and her memorandum here in opposition to the planning director's motion to dismiss. We'll take a few minutes and do that right now. We'll just remain silent as we do that. Did you get one? Yeah.
I'm done reading.
Thank you.
Deputy Corporation Counsel Sylvia Wan, I'm just going to note for the record that the last person speaking was Board Member John Kimura, indicating that he has completed reading the memorandum in opposition to the Planning Department's motion to dismiss. As a gentle reminder, I would just request that everybody please state your name prior to speaking, since this is a Zoom as well as in-person meeting. Thank you.
So noted.
This is Chair Kathy Lewis. I'm done reading the memorandum in opposition to the motion to dismiss.
Vice Chair Rachel Abel, I've completed reading the updated memorandum.
Scott Martin completed reading.
And you've had a chance to read it, Ms. Campbell?
I have,
Anybody
thank
that
you.
wants to read it? Okay. All right. Thank you for doing that, everyone. And so now we will go on. Then did I call the case yet? I did. I called the case. All right. So we are we're going to take argument then, oral argument on the motion to dismiss. I'll call on, the way that will work is that the movant starts the argument, the opposition then responds, and then the movant has a short rebuttal. And Mr. Stankey, are you planning on arguing?
I think it'd be the same as the council's argument, and theirs is more detailed, so I'll let them go first. I doubt I would have anything to add.
Okay. All right, then we can proceed then with the argument. And how much time? Let's see. Why don't you take 5 minutes? I'll give you a couple minutes for rebuttal.
Thank you. Good morning, Chair Lewis and Board of Appeals members. I'm Deputy Corporation Counsel Jean
Speak
Campbell.
louder, please. Thank you.
Good morning, Chair Lewis and board
Point
members.
Order.
Yes.
I was told it would be 15 minutes apiece.
By whom?
Sylvia Wan.
Deputy Corporation Counsel Sylvia Wan, I'm sorry if you were under that impression, but my email response to you was 5 minutes. 5 minutes for each
it
party.
was 15. It was 15. I asked to be able to prepare.
At this
And-
point in time, that is not what was being provided. I understand that was your request. I had responded
No, it
to you in
wasn't my
writing.
request. Okay, I don't want to argue, but I am going to make a notice in the record that for my hearing disability, I asked questions about how the procedures were going to go so I could prepare. And I asked specifically how much time and when we were going to be given to argue this. And I was told 15 minutes is what chairs provide. And
No, I'm sorry, Ms. Rohr. At this point in time, you are not recognized. Also, I would note that the person who has the authority to set times is the chair. The chair has now indicated that it is 5 minutes, and it is now the appellee's time to present. Thank you.
I'll also note we never give anybody 15 minutes to argue, especially when they presented their argument in writing. So we will continue. You will also have 5 minutes, and we'll begin now.
Good morning, Chair Lewis and board members. I am Deputy Corporation Counsel Jean Campbell, appearing on behalf of the Planning Director. The Planning Director asks that this appeal be dismissed due to the failure of the appellant to meet the requirements of your Rule 8-2 regarding standing. Standing is a critically important threshold determination that protects our entire legal system from inefficiency, abuse, and overreach by requiring that any party seeking relief from an adjudicative body, whether that be the courts or an administrative body such as yourselves, shows that they have an actual injury in fact that is directly caused by the action being challenged and that the claim is redressable by the adjudicative body. Your Rule 8-2 specifically requires that the person seeking relief has an interest in the subject matter of the decision and is so directly and immediately affected that the person's interest is clearly distinguishable from that of the general public, and that the person is or will be adversely affected by the challenged action. The action at issue here is the director's determination that minor modifications to an existing home, including the construction of a 200 square foot porch and an internal staircase, do not rise to the level of the definition of development under our state shoreline management area law, or SMA. This can be constructed, and that this can be constructed without formal SMA approval. That determination is a simple application of the SMA law to the facts of the planned construction, and the landowner who requested it deserves the finality and the certainty provided by a final decision of the director. The appellant alleges that this porch and staircase are going to so increase the use of the house that parking will spill out onto nearby Oi Street and increase that traffic such that she will not be able to safely travel that street, that she will be impeded if trying to evacuate in the face of an emergency, and that emergency responders trying to get to her house will not be able to timely get there. Appellant has provided no facts to support this exaggerated allegation that a 200 square foot porch on a home will be the cause of blocked traffic on a street that is already heavily used by the public for beach access. She has provided no explanation about why emergency responders would take a longer route on Oi Street rather than taking the most direct route from Hilo to her location. Nor has she explained why, in the event of an emergency such as a tsunami, she would be traveling on Oi Street towards the shoreline rather than in the opposite direction towards the evacuation routes established by civil defense. Even if we were to accept her outlandish allegations as truth, they do not support her claim for standing. Each appellant bears the burden of proving that they have standing, and courts have required that when someone is challenging the regulation of a third party, the burden of establishing standing is substantially more difficult. It is not the department's job, nor the landowner's job, to prove that she lacks standing. If traffic is congested on Oi Street, we are all affected. Her injury is no more significant than yours or mine. She does not qualify as an aggrieved person under Rule 8-2. Additionally, traffic congestion preventing movement to and from appellant's house is not an SMA criteria. And I would remind you that the sole basis of the director's determination here is an SMA exemption. The SMA law exists to protect valuable coastal resources along our shorelines against environmental degradation and to ensure that adequate public access is maintained from public access points such as Kalanianiole Street
1 minute remaining.
to the shoreline, not to appellant's house. Claims of injury based on traffic, short-term vacation rental use, and non-conforming uses simply are not relevant to an SMA determination. And any attempt to overturn the director's determination based on non-SMA criteria would exceed the authority of this board. The director respectfully requests that this board enforce its Rule 8-3 and dismiss this appeal based on appellant's failure to prove she is an aggrieved person having standing to bring the appeal. Thank you.
Okay, thank you. Ms. Rohr, you will now have 5 minutes. You'll get a warning at what time? You'll get a 1 minute warning, and so you can speak when you're ready. Now we'll start the timer when you begin. You're muted, Ms. Rohr. You're muted. Now you're unmuted.
Madam Chair and board members, I would like to point out things that aren't in my draft memorandum in opposition. The County Appellate's Council misrepresents the effect of expanding a non-conforming use by adding a 250 square foot second story covered deck by moving the roof out 12 feet. It's 12 by 20 feet. Oh, yeah, 12 by 20 feet over a concrete lanai. Now, if this is allowed to proceed against the zoning code impermissible law, then next the owner will submit to enclose those and will be allowed to do so, even though it's in a tsunami zone. And so it's not just so simple. And the other thing is the stairway is not internal to the existing building envelope. It also expands the non-conforming use over the land. It's the expansion over the land that is violating the zoning code. And it's well explained in my petition. And I note it in my memorandum, which is only a draft. The main point should be that Ms. Campbell filed her motion late. She didn't follow the scheduling order. She didn't file any supplementary brief on my second amended petition. She had an opportunity, but didn't. Instead, she comes in 7 days before the hearing when I have 10 days to answer. So basically, I'm asking that the board dismiss the motion to appeal based on violation of the rules, board rules, and violation of due process, so that I can continue on and present my case in chief in a contested case hearing. There's other things. I didn't say that I was something about me being able to escape a tsunami. I actually took that, I worded it as all the people in the park and my neighbors on Kalanianaole who would be going down Oe, it could create a big traffic jam. But the one other thing, there was a 2019 case at the Board of Appeals, Layla Evie Neighborhood Association versus the Planning Department. And the issue was that they issued an SMA minor permit for that giant monster house.
1 minute remaining.
And I was allowed to intervene based on standing. And I have the transcript for that, and I am going to file the transcript and the petition on behalf of Layla Evie Neighborhood Association. But the Board of Appeals, based on geographic location and the same arguments I'm making now, voted that I had standing. Thank you.
Thank you, Ms. Rohr. Do you want to have a 2-minute rebuttal?
Thank you. Yes, I'd like to rebut 3 points that the appellant made. First is that your rule 3-12A on timing of motions, I will read it to you, allows that motions may be made before, during, or after a hearing. So The motion that I filed was not untimely. It could have been filed today. Second is I will remind you once again that this is an appeal of an SMA exemption determination. That has nothing to do with non-conforming uses or zoning. Those are matters that are outside the jurisdiction of this board to hear today. And finally, if the appellant is claiming that the evacuation injury goes to everyone in the park, that is precisely what standing is supposed to exclude. That is an injury to the entire general public, not an injury specific to this appellant. Thank you.
All right, thank you for your arguments. Mr. Stankey, do you want to add anything to the arguments? I can give you 3 minutes.
Oh, that's fine. I only need one.
All right.
Since the argument of standing is really traffic related, I just want to point out Oeoe only has 4 driveways connecting to it, and the Nini Street behind it might have another 4 or 5 in between the side streets. So this traffic issue deals with maybe 9 families. So I could stand an hour and be 50-50 chance not a single car would pass. So I just want to point out the general geography of the area. There is no traffic. On Klein Aioli, right across from Richardson's, there's plenty of traffic on a weekend, but that's got nothing to do with me.
Okay, thank you. All right, with that, we'll have the arguments closed. And
Point of order, I'm just asking a question. Do I get a chance to rebut what
you can have a short rebuttal. Yes, 1 minute. You can take 1 minute to rebut that.
Okay, pause for a second. I have to read Jean's, what she said. I'm sorry.
Oh, you don't rebut what Jean said. You can respond to Mr. Stankey's new argument.
Oh, okay. Okay, I'm going to call him the landowner so that I don't repeat his name and he doesn't get offended by me. The landowner lives in California, and whoever takes care of his 3 side-by-side vacation rentals doesn't come and overlook what's going on. The streets of the Kalanianaole is packed with cars, and the only, and this is a 2-block, a double block where I live on Nene, and the crossing, the place, what do you call it, a crossing, the crosswalk is on the corner of Oe Street.
15 seconds remaining.
Cross from safely so that you can walk against traffic. And it's it's wall-to-wall cars in front of my property. So I disagree with him about parking being an issue and traffic and only 9 neighbors, because if he lived here, he would see that every parking lot down here is filled to the gills with cars.
Ms. Rowe, your time is up.
Okay, your time is up. And we did hear that last sentence. Okay, all right. I'm going to close argument then. No, I'm not going to. All right, I would at this point then entertain a motion regarding the Department of Planning's motion to dismiss for lack of standing.
Rachel Abel, Vice Chair. I move to grant the Planning Department's motion to dismiss for lack of standing in PLBOA 2025000119. In this case, it's a generalized public, one moment. This is more of a matter of construction approval in a residential, not commercial or high occupancy project. There's, for lack of evidence, I would say there's no expert testimony to support appellant, no factual showing that a lanai and interior staircase will cause measurable traffic congestion.
All right, a second to the motion?
Second.
Okay, that's Scott Martin has seconded the motion, and now it's open for discussion.
Point of order, please repeat the motion.
The motion is, Ms. Rachel Abel made a motion to grant the Department of Planning's motion to dismiss.
In detail, please. For what reason?
That is the motion that we're voting on, is the motion, the motion to grant the motion to dismiss. Any discussion? Are you raising your hand, Mr. Kimura? You're muted. Are you saying yes or no? You can thumbs up or down. Okay. All right. I am going to just make a brief, statement of my reasoning, I guess, and then that can be discussed by us. The motion to dismiss is based on the facts that are in the pleadings, and based on the pleadings, it appears to me that the injury that's being alleged is too speculative. And the courts have reiterated, courts that look at standing emphasize that, and I think we have language to that degree in the briefing that, and in fact, in Ms. Rohr's memorandum as well, that those facts cannot be speculative. And I do think that it's speculative to say that basically what Ms. Abel said, that the building of a porch, which reaches out 12 feet, or whatever, it's just too big of a leap to say as a fact that will do all of the things that Ms. Rohr has alleged in terms of her injury. It has to be concrete, it has to be traceable to what the planning department has done. I find that traceability also to be speculative at best. If anybody wants to add anything to that. All right, then I guess we will call for the vote on that. Bethany, will you repeat the motion that we're voting on, please? And then take the roll call vote.
Yes, Chair. On the motion to grant the Planning Department's motion to dismiss for lack of standing, Board Member Rachel Abel,
Aye.
Board Member John Kimura,
Aye.
Board Member Scott Martin,
Aye.
Chair Kathy Lewis.
Aye.
Chair, you have a unanimous decision.
Thank you. All right, with that then, what?
The motion is granted.
Yes, well, yes, the motion is passed, and we will not continue with the contested case hearing in this planning matter. And you know where this is going. I would like you, Ms. Campbell, to prepare a very detailed, factual, and conclusions of law order for us to consider. And Ms. Rohr, Ms. Wan will give you some timelines regarding that.
Deputy Corporation Counsel Sylvia Wan. So to the parties, the chair has ordered to the appellee department to prepare a form of the order, which would include a findings of fact and conclusions of law, as well as order of the board, to be due on June 5th, 2026. The non-prevailing party, which would be the appellant in this matter, can provide objections and any objections and or comments to the form of the order due 15 days after, more or less, which will be June 22nd, 2026. And because we have a landowner who is separate from the appellant, the landowner may also provide comments and objections by the June 2022 of 2026 date. Thank you.
All right, that concludes that matter, and we will now move on to the next contested case, which is also Claudia Rohr, PL-BOA-2025-000121. This is, I'm calling the case appeal of a decision by the Director of Public Works dated April 1st, 2025. This is regarding issuance of a building permit number PW B 2024 005123. And first, Bethany, are there any public testifiers on this agenda item?
Chair, you have no public testifiers.
Okay. We have in front of the board a motion to dismiss filed by the Department of Public Works and responded to by Ms. Rohr and objected to, obviously opposed. And so once again, we will hear oral argument on that motion to dismiss. This again is for standing. And so we have, again, a 5-minute argument from the movant first, and then Ms. Rohr, you'll be able to rebut with 5 minutes, or excuse me, oppose your argument in opposition for 5 minutes, and then department can have a short rebuttal.
Chair,
Yes.
Deputy Corporation Counsel Sylvie Wan, prior to us moving to the argument from the department, I just want to acknowledge for the record that the board has already received and read Ms. Rohr's opposition memorandum. I know you noted it. I just want to note it for the record since it was read at the previous hearing. I just wanted to ask and get acknowledgement from the appellee as to whether they had received a copy of that memorandum in opposition and if they had read it.
I received it and read it. Thank you.
Okay, thank you. That's all your.
Okay, and then Mr. Stanky, I don't mean to keep you out of the loop. Do you want to make an oral argument here, or do you want to see how it goes? Or
Yeah, I
couple
can't imagine
minutes.
I would. I'll let county council make the argument.
All right, very good. All right, then, if you're ready, we're ready to hear your argument.
Thank you. Appellant addresses standing and
A little louder.
Appellant addresses standing in her petition, the latest one that was approved on page 3. And basically, she states that, standing to appeal based on asserted injuries to property rights. And the argument is that adding a 240 square foot lanai would have cumulative and significant adverse, and I'm quoting it, cumulative and significant adverse effects on the surrounding neighborhood and appellant's property rights, unsafe road conditions that limit the walkability of the neighborhood and restricted emergency services. There's a lot of vague general statements saying that this lanai, I'm reading into what she's saying, but it looks like she's arguing that the lanai would draw more vehicles, which would affect her walks and her ability to receive emergency services and access her driveway. But then she states in her pleading that it would affect everybody. And then on page 4, there's a photo of a vehicle backing out of one of Mr. Sankey's properties. Vehicles back out of everybody's property. Everybody has a right to reverse their vehicle. I don't see how any of that affects her at all. the appellant. Standing is a threshold issue. It's jurisdictional. It can be raised at any time, before a hearing, during a hearing, after a hearing, even on appeal. Appellate court's gonna say, hey, look, you guys don't have standing to even address this. We're gonna reverse it. So
Nice and loud.
standing can be raised at any time. And so we're raising that now. We raised it in the motion, raising it here. So examples of standing, say, for example, I'm going to give you guys some parameters why I think where standing could exist. So say, for example, your neighbor gets issued a building permit, but that building permit is issued within the setback. And so then that would give them standing because it's in the setback. It's affecting me particularly, and I'm going to be injured because you're not supposed to have that building in the setback. It could, maybe your neighbor was issued a permit that would block your driveway access, that would be affecting me, or that it interfered with drainage and it's affecting my property. It must be direct, distinguishable interest, different from the general public. Her allegations don't even get to a point where it would be direct and distinct towards her. Her argument is that it would affect everybody in the neighborhood. For example, the adversely affected, you got to have some type of injury, such as a loss of access, flooding, diminished use of your property, or a safety concern. Someone who simply disagrees with the project as a concerned citizen but cannot show specific individualized impact does not have standing because their interest is no different from that of the public at large. And that's what is happening here. It appears the appellant just doesn't want this to be built. And we can't do that, you know, like maybe I buy a piece of property and I don't have neighbors. They, in a residential neighborhood, they get a permit to build homes. I cannot just go and say, I don't want those homes to be built because there's going to be more cars in the street. We cannot do that, and that's why we have standing. Just some other examples of where standing may be satisfied. Say, for example, the
1
county.
minute remaining.
Thank you. Say, for example, the county approves a variance to allow a commercial building to operate much closer to somebody's property than would normally be permitted. That person could argue standing because they're deviating from the standard law. It's going to directly affect them rather than everybody else who, you know, people who live 3 streets down. Another example is a restaurant owner could appeal a denial of a permit because they have a personal interest in that. And that's generally what the Board of Appeals hears is somebody appealing a decision that directly affects them. And so, yeah, I'll just end with, you know, this photo of somebody backing out of a driveway is not enough to establish standing. And I'd ask that the Board of Appeals dismiss this for lack of standing.
Okay, thank you. All right, Ms. Rohr, you ready for your rebuttal?
Yes.
Okay.
Both of the counsels for the county appellees in both of these cases are just not up with the environmental law on standing. The latest case, Protect and Preserve Kahoma Awapua'a Association versus Maui, 2021 case, is very clear that there is no such that in that case it's instructive because the Planning Commission narrowly interpreted their own rule on standing, and the Supreme Court or the ICA held that it has to be broadly interpreted and that it doesn't matter if the injury is the same as the general public as long as the litigant was actually injured. Now, everybody's arguing the merits of the case in this portion. And I would like to say that the Rule 3.2 about motions is affected by the board's rule on reading your rules together. And when you read the rules together, no way is it just procedure to file a motion to dismiss 3 days before the hearing, as in this case. And I would say that the lack of notice, there was no notice of what was going to be heard at this hearing. And the chair did not file an order saying that my opportunity to write a memorandum in opposition was lessened to 3 days. So by your own rules, you must deny this petition. This motion to dismiss. The law in the case I just cited you to, you should look it up. Because I only have whatever minutes, I don't have the I guess I could. I think I found it. Hold on. Okay. The councils know this law, this case, because it was published in La Justia. There were articles in the Civil Beat. There was articles in the Maui news organization, and it's been cited for the fact that it changed the way that courts look at litigants in environmental cases involving standing. But you do know when you break your own rules, what happens. It's just going to come back. And it won't look good, of course, if it does come back. You won't be here, but you're putting this on another board, just like in the Ford case.
1 minute remaining.
I have submitted, I don't want to argue the merits. I want to write to a contested case hearing. And my exhibit 19 at page 11 demands my constitutional rights based on property rights and my right to live in a safe and healthful environment under the Hawaii Constitution. And due process is due to me. When you read the rules together, you can't submit a motion to dismiss. First of all, their own arguments were that somehow my amendments weren't allowed. But of course they are, because the rules say they are allowed. But they had plenty of time to submit supplementary briefing, and they didn't do it. Instead, they come up with this weird strategy. And he just said a person has standing if their access to their driveway is impacted. Of course, and I've submitted photographs with all the parties in the 2 buildings next to this building where there are porches.
Okay, now that we've
And
allowed you more than the time.
The parking problem.
We have allowed you the time. So
you allowed him extra time too. Thank you for listening. I hope that you stop and consult the case that I just mentioned.
okay, thank you very much. Rebuttal, 1 minute.
So the case that's cited in the appellant's opposition, Sierra Club v. Department of Transportation, and that's a case that articulates the standard for standing in cases filed in Hawaii Circuit Courts under the Hawaii Environmental Policy Act. We have a different standard here. In response to what Ms. Rohr stated, that she has a constitutional right, people don't have a constitutional right to interfere with their neighbor's building permits. I'll just end with the statement that we articulated in the briefing and that I've articulated here. Standing is something, it's a threshold issue. It determines who can seek redress in front
10
of the
seconds
board,
remaining.
in front of the Board of Appeals. And as shown in the pleadings and the argument, there's no standing here, and we'd ask that the case be dismissed. Thank you.
Okay, hang on just a second. I'm going to confer with my counsel here. All right. Thank you for your arguments, and
I'm still in
the
meeting.
landowner, yeah, Mr. Stankey.
Another half an hour. Thank you.
Thank you. Okay. So we'll close the arguments on the motion to dismiss, and I will then entertain a motion regarding the motion to dismiss.
Chair, I'd like to make a motion to dismiss.
Mr. Martin, you're recognized for that.
Make a motion to affirm the planning director's decision in the case of Board of Appeals 2025-000-121. The decision was not arbitrary, capricious, nor was it abuse of
I'm going to
discretion.
stop you on this, Mr. Martin. I see where you're going. We're going to look just at the motion to dismiss, not the merits. So we're just dealing now with this one motion,
Okay.
whether to grant or deny. So I'll say again, do I entertain a motion on the motion to dismiss?
Make a motion to dismiss. To grant the motion to dismiss.
Okay, Mr. Martin, you've made a motion to grant the Department of Public Works motion to dismiss. Is that correct?
Correct.
All right. Can I get a second on that?
John Kimura, I second.
Thank you, Mr. Kimura. Seconded the motion. It is now time for discussion. Is there any discussion by any of the members?
No discussion from me.
Well, Deputy Corporation Counsel Sylvia Wan, at this point, because you are the mover of this motion, can you please provide a sentence or two basis supporting your motion?
Okay. In support of the motion to dismiss, there's an abundance of lack of evidence with respect to standing. I find the county's legal argument solid and undisputable with respect to standing.
All right, I'll go ahead and repeat what I've said before because this is a separate case. The allegations of injury the injury must be to the individual, regardless of what case we're under. It is a foundational concept in standing that the person in front of us must have the injury, and it must be concrete, and conclusory statements don't support an injury. It has to be something that is traceable to the actions that are being challenged. And I find that here we have conclusory allegations regarding a lanai that will then increase traffic to the extent that it's going to block the roadway. We do have facts of record that are shown in photographs and so forth, that their public is parking on these streets as well to access the very nearby beach parks. We have no way of redressing that injury. And so for those reasons, I find this motion to be well taken. Any further discussion? All right, then, Bethany, if you'll repeat the motion, please, and take the roll call vote.
Yes, Chair. On the motion to grant the Department of Public Works motion to dismiss, Board Member Scott Martin,
Aye.
Board Member Rachel Abel,
Aye.
Board Member John Kimura,
Aye.
Chair Kathy Lewis.
Aye.
Chair, you have a unanimous decision.
Thank you. All right, with that, the motion to dismiss is granted and the contested case hearing will not go forward. Mr. Salas Ferguson will ask you to prepare a nice detailed with law and citations to the record and all those good things, supporting the order to grant the motion to dismiss. And you'll get some dates on that from Ms. Wan, and Mr. Stanky and Ms. Rohr, you will also have some dates here being given to you.
Thank you, Chair. Deputy Corporation Counsel Sylvia Wan. At this point, the prevailing party, the appellee in this matter, the department, is ordered to prepare the form of the order to include findings of facts, conclusions of law in the form of the order that will be due on June 5th, 2026. The other parties, including the non-prevailing party in this matter, which is the appellant, as well as the landowner, will be provided an opportunity to send to the board written objections or comments that will be due by June 22nd, 2026. Those should be filed with the board as well as provided to the other parties. Thank you very much for your attention to this matter.
All right, that does conclude the contested case hearings in this matter. We thank everybody for their time and attention.
Point of order.
Yes, Ms. Rohr.
Madam Chair, I'd like to request that the board or the planning department hire an outside contractor to write a complete transcript of this hearing for me that will come out before the final order is written. The reason being that they have a very large budget, including $50,000 for ADA. And I'm sorry, but all these arguments that you folks are making are important for me to be able to follow. I can't follow these kind of dispersed arguments, and I just can't do it. I have a 20% hearing loss. That means that 20% of sound I don't hear. And as an accommodation under the ADA, it's in the budget and it won't be a burden to the administrative staff. And it's
okay. That's enough. We've got your request. I'm just going to ask you. It's not up to me to grant or do that, or this is not an our bailiwick. I'm just going to ask you, in case, just listen, please. In case it doesn't happen, you should print your Zoom transcript. Will we be providing a Zoom transcript as well or not?
So I'm going to just read to what has already been agreed to by the department as well as the board regarding transcripts in this matter. Just give me a moment to pull it up.
What?
Just give me a moment to pull it up. So as previously communicated to you.
I know you don't repeat what's confidential. I just wanted that on the record. That's all. I just wanted to make that clear on the record that I could not hear what happened today. And I'm looking at the transcript and there's words missing. So I just made a point, and I'll make it again, that I could not hear 20% of everything that people said. So the sentence is, were not a complete sentence, and I couldn't follow along. And I'm the losing party. So it's important that I get effective communication, and it will be delayed, but a transcript that's complete with all the words and not like this one here or a Zoom transcript that's missing words or words are made into a different word. That's what my mind does.
All right.
It misses the words.
We've understood your
I made
request
my
and
point.
it will be taken under advisement. Thank you.
Yes,
All right.
I just
We
thank you. Wait,
conclude
can
this
you give
matter.
me time to save the transcript, please? I'm trying to find
Sure.
the button.
I don't have any power over that.
Okay, hold on a second.
Ms.
There's
Rohr,
a-
can you please just turn off your microphone while you're utilizing the application? Thank you.
Yes, but you have to, don't sign off till I hit the
We're
button.
not
You're not
signing
signing
off. We
off.
have more business to go forward with, so. All right, the next item on our agenda then is the minutes, correct? Yeah, the minutes. We're moving on then to approve the minutes of the January 9th, 2026 Board of Appeals hearing minutes. Do we have any public testimony on this item, Bethany?
No public testimony.
Thank you. There's no public testimony, so have all the board members had a chance to review the January 9th, 2026 minutes?
Mhm.
All right. And does anybody have, oh, well, since you all have then, I would entertain a motion to approve the January 9th, 2026 minutes, unless you have any additions you want to, or any corrections or anything.
A motion to approve the January 9th minutes. Scott Martin, thank you.
Don Kimmerer, I second.
All right, I'm just going to repeat that Scott Martin moved to approve the January 9th, 2026 minutes. Mr. Kimura seconded, and discussion? Hearing no discussion, all in favor say aye.
Aye.
Aye. All opposed, nay.
Aye.
Hearing no nays, then the motion passes. Thank you. No nays. It's hard to say. All right, now look, we have two with the same date, so that must.
Yes, so one is minutes and one is transcripts.
Oh. Okay. So now moving on to approval of the January 9th, 2026 Board of Appeals hearing transcript. Do we have any public testimony on that agenda item?
No, Chair, no public testimony.
Thank you. And has everyone had a chance to review those transcripts? The little nod will do. All right.
Mhm.
Then, assuming that, then I'd entertain a motion to approve or correct or otherwise these January 9th, 2026 transcripts.
Scott Martin, I move to accept the January 9th transcripts for 2026.
Thank you. Mr. Martin has moved.
Don Kimmerer, I second.
Thank you, Mr. Kimura. Second. Any discussion? No discussion. Then all in favor of approving the January 9th transcript, say
Aye.
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 Aye. Any
Aye.
opposed, say no or nay. And there are no nays, so the motion passes. All right, now moving on to administrative matters. Ms. Guan, would you like to give us a status update on any appeals or anything else for that matter?
Deputy Corporation Counsel Sylvia Wan. Thank you, Chair. At this time, I will note that there are still a couple of active appeals. Belisario is still before the ICA pending additional pleadings. There's also a case with Ms. Rohr that's before the district court, the U.S. District Court, that is still pending. And as far as cases coming back, Ford and Gage has recently, there was a decision from the ICA, which is the Immediate Court of Appeals. They have reversed the circuit court's reversal. So it's coming back to the board for instructions. It is affirming the fact that the board found in favor of summary judgment, but it's coming back with asking the board to provide a findings of fact, conclusions of law. So there is still some working with the parties on getting that back on a hearing as far as to put that back before the board. So that's pretty much the larger things that are on the horizon. We do have 1250 Oceanside and that particular amended order from the board based on circuit court instruction that should be coming up soon. I believe it should be in June. So those are the things on the horizon.
And I'm just going to say, just to try to help new board members, although one of them isn't here, that on the Oceanside case, you're going to be reading a lot. Basically, you can read the Court of Appeals opinion and then the new order coming from us with findings of fact and conclusions of law. But that decision did affirm the fact that we as a board are permitted under Hawaii law to grant or deny, to entertain a motion for summary judgment, which is a little different than a motion to dismiss because it usually involves more fact finding. So that's what we've got to do, is get that record with the facts and the law. So you'll be asked to take a look at that and see what you think of that. We'll discuss it at the June meeting.
And just as Deputy Corporation Counsel Sylvia Wan, and just as a general advisement to all of the board members, as your counsel, of course, if you have any questions or concerns about your roles, responsibilities, liabilities, or otherwise obligations as a board member, please feel free to contact me, as I am the counsel for the board, and that's what I'm here for. Thank you.
Thank you, everybody. Appreciate your time and attention and all the help that you assisted with this, the technicals today. Really appreciate it. Thank you very much. We're adjourned.
Thank you.